Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. We're in Morrison versus Olson, Scalia's Dissent, 1988. Go to Giggle Scholar, and we will continue on our wonderful journey. But before I do that, I want to show you Claremont Review of Books. Claremont Review of Books is the world's premier book review publication from a scholarly but not an accessible angle from for by those people that love America. And this is one of my former professors, Charles R. Kessler. In the last edition, the winter 2024-25 edition, he wrote The Eruption of Mount Elon. And it relates to our topic today in Scalia's Dissent in Morrison versus Olson. I'd like to just read part of this, make a fair use of this. You can get there by searching Claremont Review of Books, go to their website, and then hit the little search bar and just put Mount Elon in there. What's the Mount Elon referencing? Well, if you know Charles, he's classically trained at Harvard in government. And so he's, of course, referring to Mount Vesuvius erupting in AD 79. This is in the last paragraph. So he says, as people found out when Mount Vesuvius erupted in AD 79, you can outrun the occasional boulder or shower of lava, but you can't outrun what geologists call pyroclastic flow, racing downhill at hundreds of miles an hour to incinerate you instantly and preserve evidence of you forever. Musk is our pyroclastic flow. Wow. In other words, Musk, what he was doing was with lightning speed, Musk's minions illuminate and preserve the real map of American government, public and private, a real time map of corruption in both the monetary and ideological senses of the term. See, go back to the previous paragraph, the second to the last paragraph. He says that bad government grows and grows, of course, and so proves hard to distinguish from simply big government, especially when the federal government is overspending like ours is. When Musk and Trump talk about the imperative to cut waste, fraud, and abuse, they sometimes can sound like their Republican predecessors targeting the size of government. Now, listen up because this is important. The difference is in the algorithms. What panics the government employees in the agencies is not that their overall budget or level of spending will be revealed, but that Musk's nerd army will, using algorithms the bureaucrats don't understand, light up the money trails that flow between government agencies and non-government organizations, the DEI brainwashers, left-wing academics, deluxe level subscription services to Politico and the Washington Post, all factious networks grounding, protecting, and steering the administrative state. That's right. That's right. This is such, Kessler is such a great writer. He's one of my favorite writers in American politics. And it's just so clear. What he's saying is that Musk is bringing um, accountability, basically a Republican form of government back to to our system. He mentions that Doge has sent a jolt of fear through each agency. Um, but what's this really about? If it's not just about efficiency, right? It's about accountability to the American people. That's what it's really about. Um, as Richard Painter, chief of White House ethics officer for under George W. Bush, told the Wall Street Journal, this is completely unprecedented. I've never seen anything like this. How right he is. Not that there haven't been plenty of previous calls to streamline the federal government, to appoint businessmen to office and run the executive branch as a business, to discipline spending, introduce private sector accounting practices, et cetera, et cetera. Um, he said uh, he said the problem was the problem basically government spent too much or that it attempted too much. Very insightful distinction. Um, you know, was the problem that it attempted too many of the wrong sorts of things? Was the government fat or fevered? Um, what is new in the second Trump term, as Mr. Painter detected, is the administration's clear sense, clearer than in the first term, and perhaps than in any recent Republican administration, that the problem is not so much big government as bad, factious, or oppressive government that has slipped its constitutional traces. That's wonderful. That's exactly right. Kessler nails it. Trump's political appointees explicitly target the administrative state, meaning the long term attempt by American progressives to overcome, notice this language here, to overcome the long term attempt by American progressives to overcome the separation of powers, starve the presidency of its rightful energy and responsibility, and yield the permanent political initiative to the unelected judges and bureaucrats of the Beltway swamp. That's right. Look, the administrative state, that unlovely entity singled out by the Trumpists, is defined by them to be deliberately, if quietly, an unconstitutional or even anti constitutional political scheme whose nature must therefore be kept hidden by its perpetrators from American citizens. Well, what could go wrong? It is the people's control over government that is the ultimate casualty of freeing the swamp from constitutional restraints, which is what the progressives want, what the Democrats want. The Republicans want the people's control over government. That's a Republican form of government. Some people say, you talking about uh, lowercase r or uppercase r? Well, it's capitalized in the Constitution. So it doesn't really matter. I mean, it doesn't matter if it's in the beginning of a sentence or not. I don't care about that. Uh, we're talking about the people's control over government. That's what we're talking about. And the Constitution has designed the uh, president to be responsible. The president's responsibility, he says. The progressives are trying to starve the presidency of its rightful energy and responsibility. Okay, that's what's happening. And so we have this Supreme Court decision, Morrison versus Olson, and we have the dissent by Scalia. This is our last episode on that. Go to Giggle Scholar, follow along, and go to Case Law, Federal Court. This is Giggle Scholar. Morrison versus Olson is easy to find. Scroll down to the dissenting opinion, and we're on Roman numeral 5, which is the last section. Get it? All right, here we go. The purpose of the separation and equilibrium of powers in general and of the unitary executive in particular was not merely to assure effective government, but to preserve individual freedom. Stick that on a coffee mug. Put it on a calendar. Put it on a t-shirt. What's the unitary executive? It's what we've been saying for a long time now. Article 2, Section 1. The executive power is vested in a president of the United States of America. He. Well, that's unitary. It's one person. Was not merely to assure effective government, but preserve individual freedom. So it's not really just about government efficiency. That's the E in Doge. As Kessler points out, Doge is kind of a misnomer. We're not just interested in efficiency. We're interested in accountability to the American people, which is what preserves individual freedom in a republic like ours is designed to be. And you may be disturbed by this, but there are vast powers at war with the design of our Constitution, our good design. Those who hold or have held offices covered by the Ethics in Government Act are entitled to that protection as much as the rest of us. And I conclude my discussion by considering the effect of the act upon the fairness of the process they receive. Only someone who has worked in the field of law enforcement can fully appreciate the vast power and the immense discretion that are placed in the hands of a prosecutor with respect to the objects of his investigation. Justice Robert Jackson, when he was Attorney General under President Franklin Roosevelt, described it in a memorable speech to the United States attorneys as follows. And this is, we're gonna just read through this here. There is a most important reason why the prosecutor should have, as nearly as possible, a detached and impartial view of all groups in his community. Law enforcement is not automatic. It isn't blind. One of the greatest difficulties of the position of a prosecutor is that he must pick his cases, because no prosecutor can even investigate all of the cases in which he receives complaints. If the Department of Justice were to make even a pretense of reaching every probable violation of federal law, 10 times its present staff will be inadequate. We know that no local police force can strictly enforce the traffic laws, or it would arrest half the driving population on any given morning. What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain. If the prosecutor, remember this is Robert Jackson writing in the 1940s, if the prosecutor is obliged to choose his case, it follows that he can choose his defendants. It might be in the 1930s. I have to look. 1940. Okay. Therein is the most dangerous power of the prosecutor. Did you catch that? What's the most dangerous power of the prosecutor? Are you paying attention? What's the most dangerous power of the prosecution? Are you paying attention to this? What's the most dangerous power of a prosecutor? If a prosecutor is obliged to choose his case, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick the people he thinks he should get rather than cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it is not a question of discovering the commission of a crime and then looking for the man who has committed it. It is a question of picking the man and then searching the law books. Sound familiar? Sound familiar? Or putting investigators to work to pin some offense on him. It is in this realm in which the prosecutor picks some person whom he dislikes or desires to embarrass, or selects some group of unpopular persons, then looks for an offense. That is the greatest danger of abuse, of prosecuting power lies. Wow. It is here that the law enforcement becomes personal and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. That's Robert Jackson, April 1st, 1940. Wow. Under our system of government, the primary check against prosecutorial abuse is a political one. The prosecutors who exercise this awesome discretion are selected and can be removed by a president whom the people have trusted enough to elect. Moreover, when crimes are not investigated and prosecuted fairly, non-selectively, with a reasonable sense of proportion, we're on 729, page 729, the president pays the cost in political damage to his administration. If federal prosecutors pick people that they think they should get rather than the cases that need to be prosecuted, if they amass many more resources against a particular prominent individual, or against a particular class of political protesters, or against members of a particular political party, than the gravity of the alleged offenses or the record of successful prosecution seem to warrant, the unfairness will come home to roost in the Oval Office. Who's writing this again? This is Antonin Scalia. Morrison versus Olson in Dissent, 1988. Okay? Following this? Well, I can't force you to concentrate. You're going to have to force yourself to concentrate. I can't do everything for you. Hey, listen up here. If you're a bad student, it's your fault. It's not the professor's fault. It's not the teacher's fault. Grow up. Get a hold of yourself. Exercise some discipline. I'm not here to entertain you. If you have a hard time concentrating, take responsibility for it and do something about it. And that usually means not just going over and playing a video game or watching porn or whatever the hell you do. I don't even know what you do. But if you're watching this and you got this far, good for you. Good for you. And if you're having a hard time concentrating, focus. Force yourself to do it. You will get better at it. And when you get better at it, you deserve praise because it's hard. And you're going to get smarter. I guarantee you, you're going to get smarter. Hang in there. Okay. Let's keep going. I leave it to the reader to recall the examples of this in recent years. That result, of course, he was talking about Oliver North. That result, of course, was precisely what the founders had in mind when they provided that all executive powers would be exercised by a single chief executive. Sometimes the chief executive is married. I would just point that out. They're not all single. As Hamilton put it, the ingredients which constitute safety in the Republican sense, are a due dependence on the people and a due responsibility. That's in Federalist 70. The president is directly dependent on the people, and since there is only one president, he is responsible. The people know whom to blame, whereas one of the weightiest objections to a plurality in the executive is that it tends to conceal faults and destroy responsibility. Amen, brother. Amen. That is the system of justice the rest of us are entitled to. But what of that select class consisting of present or former high-level executive branch officials? If an allegation is made against them of any violation of any federal criminal law except Class B or C misdemeanors or infractions, the Attorney General must give it his attention. That is in itself not objectionable, but if after a 90-day investigation without the benefit of normal investigatory tools, the Attorney General is unable to say that there are no reasonable grounds to believe that further investigation is warranted, a process is set in motion that is not in the full control of persons dependent on the people and whose flaws cannot be blamed on the president. An independent counsel is selected and the scope of his or her authority prescribed by a panel of judges. We're on page 730 now. Look right here in the middle. See, 730. That's the U.S. Reports, 1988, volume 487. What if they are politically partisan, as judges have been known to be, and select a prosecutor antagonistic to the administration or even to the particular individual who's been selected for this special treatment? There is no remedy for that, not even a political one. He's saying under this statute, which is unconstitutional, but which is upheld by the majority opinion in this Morrison versus Olson, mistakenly. Judges, after all, have life tenure, and appointing a surefire, enthusiastic prosecutor would hardly be considered an impeachable offense. So if there's anything wrong with the selection, there is effectively no one to blame. That's not good. The independent counsel thus selected proceeds to assemble a staff. As I observed earlier, in the nature of things, this has to be done by finding lawyers who are willing to lay aside their current careers for an indeterminate amount of time to take on a job that has no prospect of permanence and little prospect for promotion. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. What could go wrong? Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would be the reaction if, in an area not covered by this statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? That's what they do in third world countries, by the way. Autocratic, totalitarian, authoritarian countries. That's what they do. That's what the Republicans are fighting against. Praise the Lord. To be sure, the investigation must relate to the area of criminal offense specified by the life tenured judges, but that has often been, and nothing prevents it from being, very broad. And should the independent counsel or his or her staff come up with something beyond that scope, nothing prevents him or her from asking the judges to expand his or her authority if that does not work, referring it to the Attorney General, whereupon the whole process would recommence, and if there was reasonable basis to believe that further investigation is warranted, that new offense would be referred to the special division, which in all likelihood would assign it to the same independent counsel. Page 731. It seems to me not conducive to fairness. Seems that way to me too, Antonin. You're nailing it. But even if it were entirely evident that unfairness was in fact the result, the judge is hostile to the administration, the independent counsel, an old foe of the president, the staff refugees from recently defeated administration. There would be no one accountable to the public to whom blame could be assigned. Yeah, that's a problem. That's not how our system was designed to function. Congress made up this law and screwed all this up. The court upheld that law. Scalia is saying, you guys have screwed up. The Congress has screwed up. The Supreme Court is screwed up. This is bad. I do not mean to suggest that anything of this sort, other than the inevitable self-selection of the prosecutory staff, occurred in the present case. I know and have the highest regard for judges on the special division, and the independent counsel herself is a woman of accomplishment, impartiality, and integrity. But the fairness of a process must be adjudged on the basis of what it permits to happen, not what it produced in a particular case. That is a famous quote. That is a famous quote right here. Stick that on a coffee mug, put that on a t-shirt. That's July's centerfold in Natural Right magazine. Yeah, absolutely. Scalia's nailing this. It is true, of course, that a similar list of horribles could be attributed to an ordinary Justice Department prosecution. A vindictive prosecutor, an antagonistic staff, etc. But the difference is the difference that the founders envisioned when they established a single chief executive accountable to the people. The blame can be assigned to someone who can be punished. The above described possibilities of irresponsible conduct must, as I say, be considered in judging the constitutional acceptability of this process. but they will rarely occur. And in the average case, the threat to fairness is quite different. As described in the brief filed on behalf of three attorneys general, ex-attorneys general from each of the last three administrations, the problem is less spectacular, but much more worrisome. It is that the institutional environment of the independent counsel, specifically her isolation from the executive branch and the internal checks and balances it supplies, is designed to heighten, not to check, all of the occupational hazards of the dedicated prosecutor. The danger of too narrow a focus, of loss of perspective, of preoccupation with the pursuit of one alleged suspect to the exclusion of all other interests. Man, that is a good quote. It is, in other words, an additional advantage of the unitary executive that it can achieve a more uniform application of the law. Perhaps that is not always achieved, but the mechanism to achieve it is there. Yeah, I agree. Yeah. The mini executive. Oh, I love that phrase. The mini executive. Oh, see, that's a Scaliaism. He was known for this, just putting something in there that was so memorable that you couldn't forget it. The mini executive. That's what he's calling the independent counsel. The mini executive, that is the independent counsel, however, operating in an area where there is so little is law and so much is discretion, is intentionally cut off from the unifying influence of the Justice Department and from the perspective that multiple responsibilities provide. What would normally be regarded as a technical violation, there are no rules defining such things, may in his or her small world assume the proportions of an indictable offense. This is exactly what happened with Trump, exactly what happened in the last couple of years. What would normally be regarded as an investigation that has reached the level of pursuing such, uh, I don't know how to say this word. Someone help me. Picayune. Picayune manners. I don't know how to say it. I'm not even sure what it means. I think it just means small. That it should be concluded may to him or her be an investigation that ought to go on for another year. How frightening it must be to have your own independent counsel and staff appointed with nothing else to do but investigate you until investigation is no longer worthwhile, with whether it is worthwhile or not, depending on what judgments usually hinge on competing responsibilities. And to have that counsel and staff decide with no basis for comparison, that's the key thing right there. This is a really important part of the piece here. How frightening it must be. I'm gonna read that again. How frightening it must be to have your own independent counsel and staff appointed with nothing else to do but to investigate you until investigation is no longer worthwhile. With whether it is worthwhile or not, depending on what such judgments usually hinge on, competing responsibilities. And to have that counsel and staff decide with no basis of comparison. See, if you have competing responsibilities, but you have no basis for comparing them, you're going to have tunnel vision and you're going to make the wrong decision. You're going to waste resources on the wrong object of investigation. That's what he's saying. The framers cautioned against that. They didn't just caution against that, they structured the entire government to avoid that and to bring accountability to poor prosecutorial decisions, poor investigative decisions, because somebody stands for election and someone is held responsible for that. If you take any kind of prosecutorial or investigation, criminal offense investigation, out of the executive's control, then nobody's responsible. Nobody who stands for election. I'm talking about at the federal level. At the state and county level, prosecutors stand for election. So you don't have the issue. We could have a discussion about whether the attorney general should be appointed by the governor, like the federal attorney general is appointed by the president, with advice consent of the Senate. But I'm not interested in having that discussion now because it would require us to get into Reynolds versus Sims and some of the one person, one vote uh, issues regarding what the Senate is at the state level. And I think that there's a real incoherence about even what a state level Senate is. Um, so, I'm not going to get into that right now, but I think that will be an interesting thing to talk about. Wow. And to have that council and staff decide with no basis for comparison whether what you have done is bad enough, willful enough, and provable enough. Those are three things. Bad enough, willful enough, provable enough to warrant an indictment. How admirable the constitutional system that provides the means to avoid such a distortion, and how unfortunate the judicial decision that has permitted it. Oh, this is so great. The notion that every violation of law should be prosecuted, including indeed, especially every violation by those in high places, is an attractive one, and it would be risky to argue in an election campaign that is not an absolutely overriding value. Fiat justia ruat coelum. Let justice be done, though the heavens may fall. The reality is, however, that it is, we're almost done, not an absolutely overriding value. And it was with the hope that we would be able to acknowledge and apply such realities that the Constitution spared us by life tenure the necessity of election campaigns. This is on page 733. I cannot imagine that there are not many thoughtful men and women in Congress who realize that the benefits of this legislation are far outweighed by its harmful effect upon our system of government, and even upon the nature of justice received by those men and women who agree to serve in the executive branch. But it is difficult to vote and not to, it is difficult to vote not to enact, and even more difficult to vote to repeal a statute called, appropriately enough, the Ethics in Government Act. This is a deep point because oftentimes people only read the title. And so they go, "You voted against that? Oh, you must be against ethics in government." I once had a discussion in high school with a Democrat on the other side. I was writing editorials, and he was complaining that Reagan was against the Clean Air Act. And I said, "Well, can you tell me what's in the act?" And he said, "Cleaning the air." He was just reading the title. That's all he was doing. Typical Democrat. His name was Adam Foster. I liked him though. I mean, we hung out, at least at school. We never hung out outside of school, but we were on opposite sides of that. And I looked at him like, that's just like one set of syllables in a huge bill, right? That you don't probably know what's in there. Maybe you should like dig into that. Anyway, um, yeah, this is just really good stuff. If Congress is controlled by the party other than the one to which the president belongs, it has little incentive to repeal it. If it is controlled by the same party, it dare not. By its short sighted action today, I fear the court has permanently encumbered the republic with an institution that will do it great harm. Worse than what is done, however, is the manner in which it has done it. A government of laws means a government of rules. Today's decision on the basic issue of fragmentation of executive power is ungoverned by rule and hence ungoverned by law. It extends into the very heart of our most significant constitutional function, the totality of the circumstances mode of analysis that this court has in recent years become fond of. Yeah, amen, brother. Taking all things into account, we conclude that the power taken away from the president here is not really too much. Wow. It's not for the court to decide that, is what he's saying. It's not a matter of too much or too little. It's period. It's not an issue that the court can decide. The Constitution is more authoritative than the court. The Constitution creates the court, not the other way around. And so the court is responsible to the Constitution that created it. The Constitution gives all executive power to the president. It's not for the court to say, an interest balancing test where, yeah, you got it. Yeah, okay, it takes a little bit away, and that's fine. We say it's fine. You don't have the authority to say that. The next time executive power is assigned to someone other than the president, we may conclude, taking all things into account, that it is too much. That opinion, like this one, will not be confined by any rule. We will describe, as we have today, though I hope more accurately, the effects of the provision in question, and will authoritatively announce the president's need to control the executive. The exercise of the subject officer's discretion is so central to the functioning of the executive branch as to require complete control. This is not analysis, it is ad hoc judgment. And it fails to explain why it is not true that, as the text of the Constitution seems to require, as the founders seem to expect, and as our past cases have uniformly assumed, all purely executive power must be under the control of the president. Page 734. The ad hoc approach to constitutional adjudication has real attraction, even apart from its work-saving potential. It is guaranteed to produce a result in every case that will make a majority of the court happy with the law. The law is, by definition, precisely what the majority thinks, taking all things into account. It ought to be. I prefer to rely upon the judgment of the wise men who constructed our system, and of the people who approved it, and of 2 centuries of history that have shown it to be sound. Like it or not, that judgment says quite plainly that the executive power shall be vested in a president of the United States. Thanks for joining me on the Republican Professor Podcast. I've been my own host, Dr. Lucas J. Mather. I'm also your host, and I've enjoyed having you with me. We'll see you next time. It is 3 June 2025, years after Jesus. and it's a Tuesday. Take care.